Nobody tells you that the most valuable thing your business owns isn't your product, your team, or even your customers. It's your name, your logo, and the ideas nobody else thought to have first. And the wild part is, most small business owners are out here completely naked, legally speaking, one copycat away from watching someone else profit off everything they built. Let's talk about why this happens. Because it's not ignorance, it's actually a very rational trap. You're bootstrapping, you're scrappy, you hear intellectual property attorney, and your brain immediately translates that to remortgage your house. So you do nothing, which is exactly what your future competitors are hoping for. Here's a system most creators and founders never see clearly. Intellectual property law wasn't designed to be expensive. It was designed to be ignored by people who assume it's expensive. The bureaucratic language, the legalese, the filing portals that look like they were built in 1994, it's all a velvet rope that's actually unlocked. You just have to push on it. Now, the first move, and this one is completely free, is understanding that copyright exists the moment you create something original. The second you write a blog post, design a logo, record a video, or write a software function, copyright attaches automatically. And that's not an opinion. That's federal law under Title 17 of the United States Code. But here's where people get tripped up. Unregistered copyright is like a smoke alarm with no battery technically there, completely useless in a crisis. Registering your copyright with the US Copyright Office costs as little as $65 for a single work. And that registration is what unlocks your ability to sue for statutory damages, which can reach up to $150,000 per infringement if it's willful. Now, trademarks are a different animal, and this is where the stakes get almost absurdly high. You can build years of brand equity, a name, a slogan, a logo, and then discover someone filed a trademark before you did, and suddenly you're the one who has to rebrand, even if you were first to market. The United States Patent and Trademark Office, the USPTO, lets you file a trademark application starting around $250 per class of goods or services. And yes, you can absolutely do this yourself without an attorney using their T's Plus filing system. The irony is that most people spend more than that on a single business dinner and then complain that trademark protection is out of reach. Here's a trick most people miss. Before you even file, do a free trademark search on the USPTO database at uspto.gov. And also run a quick Google search, a domain search, and a social media handle check. Because a trademark conflict you discover before filing saves you hundreds in rejected application fees. Think of it as a free pre-flight checklist before you take off. Trade secrets are another budget-friendly weapon that almost nobody uses correctly. You don't register a trade secret, you just protect it through internal controls. And those controls can be as simple as having employees and contractors sign a non-disclosure agreement, which you can draft for free using templates from sites like Law Depot, or even adapt from state-specific resources your Secretary of State's office sometimes provides. Let's kill a misconception right now. The poor man's copyright, the thing where you mail yourself your work in a sealed envelope, is not legally meaningful in the United States and never has been. It's the IP equivalent of locking your car by tying the door handle with a shoelace, and it needs to stop being passed around like wisdom. The practical playbook here is straightforward. Copyright the creative work, trademark the brand identity, NDA the relationships, and document everything with timestamps using free tools like Google Drive, Dropbox, or even emailing files to yourself with date-stamped metadata. You're building a paper trail that tells a coherent legal story if you ever end up in front of a judge. The broader lesson from every scrappy brand that successfully defended its identity, think of Liquid Death fighting giants or the countless Etsy sellers who've beaten corporate copycats, is that consistency of protection matters more than perfection of protection. You don't need an IP fortress on day one, you need a reasonable, documented, consistently maintained foundation that grows with your business. Here's the philosophical truth underneath all of this. Most intellectual property theft doesn't happen because attackers are sophisticated. It happens because owners were passive. The brands that survive and win aren't necessarily the most legally funded. They're the most legally intentional. And intention costs almost nothing up front. So position size, your risk like a rational investor. File the copyright on your flagship work. Get that trademark application in early, even if it's just for one class. NDA your contractors, and set a calendar reminder every year to audit what's new and what needs protecting. Discipline, consistency, and the willingness to spend $65 before you spend $65,000. That's the entire game. And if you're ready to start building something worth protecting, whether that's through real estate investing, contracting work, or finding the right lenders to fund your next move, check out our links in the description below.